Well, first, I want to introduce myself. My name is Jesse McCoy. You may also see my name in the community as J. Hamilton McCoy. I am a senior lecturing fellow and supervising attorney for the Duke Civil Justice Clinic. And today I want to talk to you about everything you need to know about North Carolina landlord tenant law. If you have heard this presentation before, it may sound familiar, but I have added some additional detail because of COVID and the variety of moratoria that have come out over the course of the past year that anyone who is not a housing nerd like me may not necessarily appreciate, but I want to make sure that I at least give you all the information. So let's get started. In order to understand kind of what has changed in the world of housing, you first have to understand what was going on in North Carolina already prior to COVID-19. We were already in the midst of a housing crisis that largely impacted low income and low earning communities. And the way that COVID-19 has actually impacted that is it's actually exacerbated the underlying issues that we had already been experiencing before. Typically, when you are dealing with people who are facing evictions, you hear the same three kind of explanations as to why they're being evicted. It's, I lost my job, I had an unexpected medical illness, or my sole means of transportation broke down. And unfortunately, the way that our laws are set up, none of those things are legal defenses, right? So even if you have the best sob story for the magistrate that you could put together based on real life events that have decimated your household, it really doesn't matter because it's not a legal defense to evictions. Before we can get to the moratoria and kind of how they impact our eviction laws, we have to first talk about evictions in general. So I want to start off with the process. You may be shocked to know that North Carolina has one of the fastest eviction processes in the United States. I think every year we're in increasing competition with the state of Virginia for who can evict people the fastest. And I'll explain to you kind of why that is. Our entire eviction process can be completed in as little as 3 weeks. So the steps are that the landlord will file what's called a complaint for summary ejectment, and they'll get a magistrate summons, and they will send it off to a tenant. The landlord, in doing this, has the luxury of being able to pick what day they want the case to be heard. The tenant, however, does not. And this creates from the onset an issue for tenants that they have to overcome, because in as few as 7 to 10 days from the date of that complaint filing, that tenant is going to have a court date. And nobody's going to reach out and say, hey, you know, are you able to take off work this day? Or, hey, do you have childcare arrangements for that day? Nope, you're expected to be there, because if you are not there, you lose by default. After that 7 to 10 day period, you're going to have a hearing in small claims court before a civil magistrate. And at that hearing, the magistrate is going to hear from the landlord and from the tenant and make a decision as to whether or not the landlord has met their burden of proof to be issued a judgment for summary ejectment. If a judgment is granted, there is a 10-day appeal window before a writ of possession can be issued. And basically what would happen is after that 10th day, essentially on the 11th day, the landlord would come to the clerk's office and apply for what's called a writ of possession that they would then provide to the sheriff. The sheriff would ride out, provide that notice, usually either through mail or through posting on the door, and tell the person, hey, we're going to be back in 3 to 5 days to execute this writ. And once they come back in that 3 to 5 day period to execute the writ, the execution is the padlocking of the property. And for all intents and purposes, after the padlock, that's it. Game's over. The person's out. There are some other statutory authorities to suggest that you still can work out a means to get some of your stuff, but I wouldn't risk it. I certainly wouldn't risk it, because the ball kind of deflects back to the landlord's convenience and availability. And so thus, once the padlock happens, essentially for most people, the game is over. Now, if you are unsuccessful in representing the tenant in small claims, in that 10-day window after the hearing, you can appeal to district court, and the hearings in district court are for what they call a trial de novo. So you would just do a notice of appearance within 10 days. But here's the kicker. That notice of appearance has to be supported by a rent bond if you wish to remain in possession of the property. So what that means is if you want to appeal, but you don't care about staying, all you have to do is the notice of appeal. But if you care about staying, you have to pay the bond. Well, this is tricky because the bond itself is equal to the amount of uncontroverted rent that is due. And a lot of tenants say, well, if I had the money to pay the rent in the first place, then I would have paid it. I wouldn't be waiting to put it into a bond. And they would be absolutely correct, right? So the problem for us oftentimes is trying to get those cases into district court. And typically for most people who are doing tenant advocacy work, getting those cases into district court is going to usually revolve around whether or not there are counterclaims that are associated with the case or other affirmative defenses that we might be able to raise. Depending on where you are in the state, eviction cases operate on different schedules. So in Durham County, where I practice, eviction cases are heard 1 week every month, usually the first Monday and Tuesday of the month. And in other counties, so once we go out to the Vances, Granvilles, or most rural areas, you're going to have court on a quarterly basis, and it's just going to be associated with a regular civil docket. So there's no specific thing to say these are housing cases or no, they're just put on a regular civil docket and they'll deal with them on a quarterly basis, having court 4 times within the year. Evictions are a huge national issue. If you've been reading on this, you see that there's been a growing push for what's called civil Gideon. All that is people are trying to assess whether or not there should be a right to an attorney for all tenants who are facing evictions. And opinions are all over the place about it, but what we do know is the trend right now says yes. So a lot of states in the Northeast, including states out west, have already gone ahead and said we're going to honor the fact that there should be an attorney involved in all landlord-tenant eviction cases. Why? Well, because first off, landlords in 80% of the cases that they file are represented by counsel, whereas tenants in most of the cases that are filed against them are not. And what we have seen in study after study is that when lawyers are involved in representing tenants, tenants are 80% more successful in avoiding eviction judgments. So there's a push for that, and there's also a push for civil expunctions. And just to give you a little bit of information about that, eviction judgments in and of themselves carry significant collateral consequences. So we're all familiar with the fact that if an eviction is entered against someone, it's going to immediately disrupt their ability to find alternative housing elsewhere. But it also is going to be something that gets posted on a credit report. And that has all other types of detriment. So for instance, if you're seeking a loan, if you say, I don't want to rent anymore, I want to go get me a mortgage and buy me a place. Well, guess what? You're probably going to get denied because now you have this eviction on your record. The actual physical removal could disrupt where your kids go to school. It could disrupt the social structures that you have to support you in raising your kid, educating your kid, your access to, for a lot of people, access to public transportation. It's going to be halted. We also know from the studies that have been written that eviction is a social determinant of health. So people are having health issues as it relates to manifestations from the eviction. And when you look at all of that in kind of a nutshell, what it suggests is that eviction is a cause of poverty and not merely a symptom of poverty. So I want to talk about North Carolina evictions specifically. The most common eviction that we have in the state of North Carolina is based on non-payment of rent. This is governed by 42-3, but essentially all the landlord has to do is to show that he made a demand for the rent, he waited a 10-day grace period, and that the rent still hasn't been paid. That demand that the landlord has to make, it does not have to be written, it can be oral, but it has to be unequivocal. So as long as the landlord has made that demand, waited the 10 days before filing suit, and then filed suit, if the rent still has not been paid, that's it. game over. And for the people who have lost their job or had unexpected medical issues, then the likelihood is that the issue that created their inability to pay hasn't gone away yet. Even though it's no fault of their own, it hasn't gone. We do have some defenses under North Carolina law to that. So if the tenant does find a new job and is able to tender the full amount of everything that is due for rent plus the cost, then the landlord will be barred from being able to move forward with an eviction. Now, this has to happen before the hearing, but herein lies the deal. If you are advocating for a tenant and you present all of the money that needs to be paid before the hearing, and the landlord decides, you know what, I don't even want it anymore, I just want to evict. Well, guess what? You still are supposed to win that case, because tender isn't about acceptance of the money. Tender is about being ready, willing, and able to provide it readily. So as long as you were able to provide it readily and you demonstrated your ability to do so, the landlord cannot unilaterally say, well, I just don't care, I don't want it. Insufficient demands, you're going to see that a lot. The landlord can't say, excuse me, if you're not too busy, maybe, possibly, could you maybe pay me some rent? It can't be that. It has to be unequivocal. I want my $850 by the first of the month, right? Has to be unequivocal. We'll deal with some other defenses as we go, but just to give you a precursor to that, retaliatory eviction. So we have a lot of cases, particularly nowadays, where people may not have been paying rent for several months, but the landlord was cool with it. There was no problem. No problem. The landlord said, oh, we'll wait. Oh, we'll see what happens. Oh, no problem. But when the tenant started complaining about conditions related in the house, pest control issues, structural integrity issues, electrical issues, plumbing issues, well, now the landlord says, well, you got to go. If you're going to complain about issues, you have to go. Well, guess what? That is called a retaliatory eviction. And retaliatory evictions are an affirmative defense. So that means that there, first of all, is a rebuttable presumption that whatever the tenant has complained about, if they show proof, is true. And the landlord has a 12-month look back period where the court is going to say, all right, was there a problem in May? Was there a problem in June? Was there a problem in August? And as they look through all these different months to assess whether or not there were other issues, if they see the same consistent issue, but no action taken by the landlord until that complaint was registered about conditions, then they're going to assume that this eviction case is done in retaliation. And if they assume that the eviction case is done in retaliation and the landlord does not refute that presumption, then guess what? Affirmative defense, landlord cannot move forward with an eviction. Habitability concerns we'll talk about in a little bit, but habitability concerns also offset what the rental amount may be. So let's say you're renting a place for $1,100 a month, but given all of the defective conditions of the unit, it's not worth $11,000 a month, $1,100 a month. It's not worth that. Maybe it's only worth $400 a month. Well, the court has the liberty to hear evidence as to whether or not the diminished value should be imputed as the new rent. And if that's the case, they can actually backdate that diminished value to the initial date that the complaints about the conditions was lodged with the landlord. So for a lot of people, this offset or this abatement, what we call in North Carolina, will actually counteract a lot of the amounts that are owed in rent. And if it counteracts fully to the point where you don't owe anything, then guess what? The landlord loses their eviction case. Next up is my least favorite type of eviction. It's a holdover eviction. And holdover evictions are my least favorite because all that is required is that the lease period has expired and the landlord has made an unequivocal notice to quit, saying that we do not wish to continue in this landlord-tenant relationship. A lot of people get hung up on this because they'll want to know, well, why? I mean, I've been a good tenant for 15 years and I always pay on time and I always do what I'm supposed to do. Why wouldn't he renew my lease? Why wouldn't she want me to continue living here? And the problem with that is it doesn't matter. As long as the landlord isn't using any discriminatory things that will violate the Fair Housing Act, the landlord doesn't have to tell you why they're not going to renew because it's not your property. They have conveyed to you a possessory interest for a defined period of time that has now expired. And now they want to exercise their ownership to do whatever they will with that property. So what often happens in North Carolina is people will have a defined lease term, typically 12 months. And after 12 months, by operation of law, you automatically convert in North Carolina to a month-to-month tenancy. Now, this can be argued because if your frequency of rental payment isn't month to month, let's say you pay week to week or year to year, then the court can infer that there was another intention between the two parties and create a different lease term. But barring anything else, the court is going to deem it to be month to month by operation of law. And under North Carolina General Statute 42-14, we find out kind of what kind of notice is required in order to end this relationship. Year to years require that at the end, by the end of the, before the end of the lease term, that you provide a 30-day notice. Month to month requires a 7-day notice. Week to week requires a 2-day notice. But again, you have to give it to them well before the end of that lease term period. The defenses here would be waiver. So classic example is landlord sent me a notice to say he wants me out by the end of March. Yet come April, landlord accepts my rent again. Well, guess what? The landlord has waived his ability to evict me based on the March notice and has to provide me a new notice to have me out in May. Insufficient notice to quit. Again, as we talked about before, you cannot be uncertain in these notices. You can't say, hey, if you're not too busy in 7 days or whatever, could you possibly move? It would be really helpful if you could. No, you have to say, I want my property back. I do not wish to continue in the landlord-tenant relationship. Consider this your notice. Please be out by specific date. Breach of lease evictions. So these are interesting. Normally, if I could see everybody, I would say, raise your hand if you've read every single page of your lease, all 27 pages of it. And most people would front and say they did, but most people have, right? Each one of those pages contains terms and conditions for which any of those violations could serve potentially as a basis for a breach of lease. But what you often see with these kinds of cases is this is a second bite at the apple for the landlord, because what's the most important and usually the first provision of a lease is to pay rent, right? So if you didn't feel confident that you could get them out on a failure to pay rent based eviction, you can cite breach of lease and have the breach be failure to pay rent. But it doesn't just have to be rent. It could be noise violations. It could be, in some cases, housekeeping. It just really depends on how the lease is structured. But what is required is that the landlord has to ensure that they have provided you with sufficient notice about the breach and given you a reasonable time to correct the breach. So usually that's going to come in the form of a notice of lease violation. And then they give you a reasonable time, and reasonable is in the eye of the beholder, but it really depends on what it is that they're complaining about for the breach. And then if you don't fix it, it's going to be called a notice to vacate, which will be the second document you're sent from the landlord prior to them filing the complaint for summary ejectment. Now, there are defenses to this as well. So first off, notice is everything. And again, as we talked about before, it has to be unequivocal notice. So if the notice is in any way insufficient, then you can fight against it. But more important than that is under North Carolina case law, at least as read in the 70s when the opinions came out, these lease forfeitures are frowned upon by the court system. And so the only way that the court system was willing to engage in these, at least in the 70s, not now, the only way they would be willing to engage in this would be if the landlord has reserved a right of re-entry clause in the lease. So the first thing I check for whenever I see these kinds of cases is I get a copy of the lease and I check for the right of reentry clause. Now, some of you may be confused because you may see a lease and it says right of entry, and you read that and you say, oh, they have it. That's not the same thing as a right of reentry clause. Typically, you want to look in the paragraph of the lease that concerns default. And it should say something to the effect of, upon breach of any of these conditions, landlord reserves a right to re-enter and retake the property, blah, 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 blah. That's a right of reentry clause, right? So if there is no right of reentry clause, the landlord cannot even use this basis as an eviction. But in most cases, particularly if they're using more massively produced leases, they're going to have it. In addition to that, you can also have, same as before, retaliatory evictions. If you didn't have an issue with any of the lease violations until a tenant complained about conditions, guess what? There's a presumption that it's retaliatory. Also, waiver of a breaching condition. So if you said I violated the lease, but again, you're continuing to accept my rent and treat me like a tenant, then guess what? The argument can be made that you have waived your ability to evict me based upon that condition. Now, this I know is a slide that every time I show anybody, their eyes pop out of their head because it's a lot of words and it's really small print. But this is probably the eviction basis that we see least of all. And this is criminal activity evictions. The main thing that I want you to take away from this slide is that for private landlord-tenant leases, and I'm emphasizing private landlord-tenant leases, the unit has to be involved in some way, shape, or form in order for this to stand. This is not a general broad brush for any kind of criminal activity people get engaged in off the property, automatically being able to evict them from their housing. No. So classic example is this. If someone commits a robbery, God forbid, but if they commit a robbery at South Point Mall, then that is insufficient to support a criminal activity eviction from a private landlord. However, if Walter White and Jesse decide that they're going to start cooking up blue meth in the apartment, well, certainly now you can be evicted because you're using the apartment in and of itself for the furtherance of the crime. Okay, so the main thing is if it involves getting caught up, then you have a basis, if the unit is involved, to be evicted. This is vastly different from public housing, and we'll talk about that in a little bit. But for private landlord-tenant, it must use the unit in some way, shape, or form. Now, in talking about public housing, I don't know how many people are involved in trying to deal with public housing cases, but public housing cases are very, very heartbreaking for a number of reasons. First off, for criminal activity evictions, the federal law actually allows for an entire family, an entire household to be evicted if somebody in that household is accused of certain kinds of crimes, particularly drug-related criminal activity. So what that means, what we established in the Hovey Rucker case, is that an 86-year-old grandmother who has no idea what her teenage grandson is involved in, and God forbid her teenage grandson gets involved in drug activity or suspected of being involved in drug activity. Well, that 86-year-old grandmother is at risk of being thrown out into the street by the housing authority because the federal courts do not recognize what used to be called the innocent tenant defense. It doesn't matter if one person is there, everybody has to go. This is a situation where North Carolina law is actually a little bit better than federal law is. North Carolina has established that before everybody can be kicked out in the street, we have to establish some degree of discretion and show that that discretion was exercised. So what that means generally is, were there any alternatives short of throwing this entire family out on the street? Is there any alternative? And what was the rationale for not supporting one of those lesser alternatives? Now, does that mean that people still won't be thrown out in the street? Absolutely not. Right? Absolutely not. But at the same time, if there's a hearing on this, then anybody who's representing the local housing authority has to be able to show how they exercise that jurisdiction, and what battery of tests or analysis they did in order to support that the entire family has to be removed. Lastly, it is important to note another heartbreaking fact here, that for public housing, you aren't required to have a conviction in order to be removed. I'm going to say that again. The accusation in and of itself is sufficient for the housing authority to remove the family. And we've seen cases throughout history where, people take advantage of that, right? So it is very important to understand, if you're counseling clients who are in that situation, they seem to believe in the American notion that you're innocent until proven guilty. That applies everywhere else but public housing evictions, right? Here, it's more so about what evidence did the officer or the housing authority itself collect to establish that it's more probable than not that what they're accusing you of occurred. We've talked about retaliatory eviction, so I won't waste your time too much about that. What I'll say is it's going to be considered retaliatory within a 12-month look back if the person has reached out to the landlord about repairs, if they've reached out to a government agency or like housing inspectors, if they've asked the government agency to issue a formal complaint, any of these legally protected activities they can do, because the whole point of this is that people should be able to complain about issues in the unit that are legitimate. The caveat here is that the landlord can still prevail if they can show that the tenant breached the lease and that the breach is the basis of the eviction, right? It can also prevail if the tenant is a holdover, or if the habitability concerns that the tenant is complaining about were caused by the tenant. I know that's shocking. There have been cases in the past where tenants have said, I'm going to take matters into my own hands, and they end up messing stuff up. And as a result, they try to blame the landlord for the issues in the unit. It doesn't happen as frequently as people would have you believe, but I can't lie and say that it does not. So it is important to see, depending on your housing inspector that serves your area, oftentimes when they do a report, they will list out the things that they feel like are attributable to the tenant, as opposed to the items that they feel like are attributable to the landlord. So it's always a good idea to get a copy of any inspection report if there was one. Now, we've talked a lot about what happens if the tenant is the issue, but what happens if the landlord is the problem? So when the landlord is at issue, then the tenant has a few options that they can pursue on their own. They can file affirmative claims against the landlord, or if they're already being sued for summary ejectment, they can file counterclaims against the landlord. So the landlord has certain statutory duties. And I say statutory duties because most people know about something called the implied warranty of habitability. I think in your first year property classes, they teach you that in all leases, there is an implied warranty, an implied agreement that what they are renting to you is going to be fit and habitable for your purpose of living in it. It is not going to be trying to kill you, right? But in North Carolina, we've taken it a step further and we've codified it to make it a statutory duty that the landlord provide fit and habitable premises in 42-42. And we've even gone down the line to kind of enumerate what things we believe are important in order to preserve fit and habitable housing. So if the landlord is violating that statute by failing to do so, and if you can prove it through inspections, through pictures, video, complaints, whatever the case may be, then you have a basis for both an affirmative claim or for rent abatement. Breach of the implied covenant of quiet enjoyment. So what this means is the landlord can't unnecessarily interfere with your possession of the unit. The landlord can't decide that they're just going to walk into your unit at 8 o'clock at night because they feel like it. The landlord can enter your unit during appropriate business hours if it is for an appropriate business function. So if the landlord is trying to change the filters or make repairs, that is an appropriate business function. However, if they just like coming in at 8 o'clock because they see your husband's going to work and they want to peep in on you, that's a breach of the implied covenant of quiet enjoyment. We also have some business related statutes that can be filed as an affirmative case against landlords as well. We've got case law that establishes that a landlord is a producer of rental property and that a tenant is a consumer of rental property, and that the continued collection of full market rent, knowing that the property is not worth the amount given the gravity of the conditions, is deemed to be an unfair and deceptive trade practice. And the reason this is important is because it sets the landlord up to be potentially liable for treble damages, triple the value of anything that was affected or anything that was lost, and attorney's fees. So for those of you on the private market who, probably are representing people in this aspect and aren't getting that much money for it, here's an opportunity to try to punish the landlord and have them pay your fees. In addition to that, unfair debt collection. So if the landlord engages in any kind of threats, coercion, anything that they're not supposed to do in an attempt to collect on a debt, they can actually be held responsible. And the penalty for this is anywhere from $500 to $4,000 of a civil penalty per violation, or punitive damages. You can't get both. You have to pick one or the other, as well as attorney's fees. So these are really good things to have in your arsenal if these things come about, and if you feel like it's something that might be beneficial to the case that you are working on. I want to talk a little bit about the types of subsidized housing. I won't go into a lot of detail, but I just want people to be able to understand the differences between them so you know kind of the impact for each. Public housing authorities can operate their own public housing programs where they are the actual landlord. So people classically know these as your project areas, but the authority itself is an autonomous, not-for-profit public corporation that allows it to work in conjunction with local governments and agencies to develop long-term housing strategies for the people. So in conventional public housing, it's owned by the housing authority. The tenant's rent is based on their income, and there's a subsidy that's attached to the rent, but the subsidy doesn't go to the tenant. It offsets the rent for those units. That's very different from the Section 8 program. And I say Section 8, I mean traditional Section 8, or what we call now Housing Choice Voucher Program. The point of the Housing Choice Voucher Program is to put people in a standing on the private market where they are able to rent, but to not throw them out there to be responsible for the full amount because of their income and their qualifications for the program. So it's administered by the Public Housing Authority. And all it is the people who qualify will get a subsidy that is in the form of a voucher, and they can take that voucher on the private market and try to secure housing with any private landlord who's willing to take the voucher and be bound by the terms and conditions supporting that voucher. Terms and conditions, most importantly, are annual inspections, right? So the landlord has to be willing to open the property up to be inspected by the housing authority on an annual basis and make sure that anything that needs to be repaired is repaired immediately. But for all intents and purposes, after that voucher has shifted to the landlord, there's nothing else for the housing authority to be involved in. So it's just a matter of the tenant paying whatever their portion of the rent is moving forward. And those tenants can only be evicted for their failure to pay their portion of the rent, not for any slowdown in the housing authority issuing out vouchers or issuing out payments, only for their inability to pay their portion of the rent. This is a little bit different from project-based Section 8, or for some of you, USDA rural housing. These programs operate similarly in that there is a subsidy, but the subsidy is already calculated within the rent. So the subsidy, what we say is it flows with the unit. This is important because if the person is evicted from a project-based Section 8 home, that means that there is no transferable voucher to take elsewhere. They lose the voucher at the same time as losing the home, and more than likely are going to lose their ability to participate in any housing programs because it's governed by the same housing authority entity. Lastly, you have something called low income tax credit housing. This isn't associated with the housing authority in most places per se anyway. These are privately owned communities that receive a tax credit. They fix rent, but they have to guarantee that they're going to allocate a certain number of units for people who qualify within a given income threshold. This is actually a creature of the Internal Revenue Service. So you see this in particularly the bigger areas, the growing cities in North Carolina. You see this as kind of the new wave of how quote unquote affordable housing is being built. But I want you to be familiar with it just so you know. Their eviction process is going to be as close to private landlord tenant as everyone else. Anytime that you're dealing with either subsidized housing or public housing, it's still going to be governed by Chapter 42 of the North Carolina General Statutes. The addition, though, is that it's also going to be governed by federal statutes and regulations. And the point of those regulations is to provide tenants due process rights. We view the subsidy, it's not quite at a right, but it's not really a privilege, like it's more than a privilege. And so in order for a tenant to be denied that subsidy, they have to go through certain procedures through the housing authority. But those procedures typically include informal grievance hearings. If it's a conventional public housing, there may be a series of hearings that they can apply to have a hearing before first the property manager, then a hearing before a neutral hearings officer, and ultimately they can appeal to have a hearing before a grievance council that is composed usually of 3 people, one of those people being another tenant in the community. So there are other processes that have to be in place. If you have any of these things come up, just feel free, shoot me an email, and I'll try to walk you through it. All public housing and all subsidized housing was covered through the months, from the months of April through July under the CARES Act. And I'll talk about that and what it means a little bit later on. These leases also automatically renew unless they're terminated for good cause. And the tenant must maintain eligibility, so they have to do an annual recertification just to show that they still are financially eligible to participate in the programs. For public housing, there are some grounds for a lease termination, and typically they break down in one of 2 things. It's either serious or repeated violations. So commonly you'll see things like housekeeping as a repeated violation, failure to pay rent, unauthorized occupants, or failure to complete the annual recertification and note any changes. But it can also be for material noncompliance or other good cause. So classic examples are what you see here: failure to maintain electrical service, no longer financially qualifying for the unit, having a unit that you choose not to occupy, criminal activity, of course, which deals with an expedited eviction, discovery of fraud on the application, failure to comply with a service requirement, or failure to accept a lease revision. So when we look at who's being evicted, it's important for you all to note that in North Carolina, there's no demographic information that is listed on our court documents or on the complaint. So most of the information that we have is anecdotal. But if you go to any landlord tenant court, anywhere in the state of North Carolina, and I've even had the luxury of going to other states outside of North Carolina, you're going to see the same people getting evicted no matter where you are, disproportionately. And essentially, there's a reason for that. Legal aid had looked in as part of our program with the eviction diversion program, which I'll talk about in a little bit, to kind of see based on the clients that they were getting, what they could identify. And they identified 87% of the people as African-American and 74% of the people as women. So Black women, no matter where you go, they're going to be getting evicted at very high levels. And again, this all breaks down to the same kind of social issues that unfortunately don't create defenses in court. People who lose their employment, people who experience unexpected medical illnesses, or people who have breakdowns of their vehicles. So with that said, you have to ask yourself, well, what did COVID bring? COVID exacerbated all those issues. So for a period of time in North Carolina, we had phased out government shutdown, which means a lot of people who worked, specifically folks who worked in service related industries, were unable to work. So that's your lost wages, right? Your lost job. God forbid you came in contact with somebody who had COVID. There's a 14-day quarantine period. Well, if you do the 14-day quarantine period for people who work in the service industry, that's an entire pay period. Not only is it an entire pay period, but if the job was able to make do with you without you for 14 days, then there's no guarantee that they're going to need you back after the 14-day period. So a lot of people lost jobs after that as well. And because of this, what you see is the face of eviction sort of changes because of COVID. It's not just low income people anymore. Now it's creeping up into middle class folks who had good jobs, but now because of no fault of their own are in a position they now have to deal with these issues. So last year, there were a number of different issues or different things that came up as an attempt to try to protect the spread, or at least reduce the spread of COVID in other places. And I want to emphasize yet again that these moratoria that we're about to discuss were designed expressly to stop the spread of COVID. They were not designed to maintain housing. They weren't designed to repair any of the issues that we've known about in eviction world forever. They were expressly designed to stop the new transmissions of COVID, because they know that when you evict people, it's a family of largely untested people who would have to now find alternative housing. And that puts other people in jeopardy in other communities when folks are constantly moving around. So the first thing we had was the CARES Act that was followed up by Chief Justice Beasley's emergency directives for the court system. We've got Governor Cooper's series of executive orders and his own eviction moratoria. And then we've got the CDC moratoria, which is kind of what is in effect at this point right now. I will tell you all, I got a ping on my phone that there's been some change, but I haven't had a chance to look at it yet to see what the changes are going to be for this CDC moratorium as of today. So, just bear with me if any of this is now obsolete. But the one that people know about most, let's start chronologically. First was the CARES Act. It was a federally imposed eviction moratorium that ran from March 27th through July 25th. It prevented evictions, but it only covered those people who were receiving a federal subsidy or living in a property that was supported by a federally backed mortgage. So if you weren't living in a place supported by a federally backed mortgage and you weren't receiving a federal subsidy, then this moratorium did not apply to you. The benefit of this moratorium is that it prevented landlords within that time frame from being able to evict if you qualified and from being able to charge late fees and penalties. And at the end of this period, if the landlord still wanted to move forward with an eviction, they had to provide a 30-day notice to you on July 26th to say that you didn't want to continue this relationship anymore. So what happens is we started looking at the numbers of people who might be evicted by the end of August when that 30 days had run out. And we started realizing relatively quickly that this number was astronomical. And this is when the media coined the term an eviction tsunami. Because the eviction tsunami was coming in August, many landlords rushed to file in early August, hoping to get a court date and be able to get people removed. But that wasn't really what protected the vast majority of the tenants in North Carolina. In addition to that, Governor Cooper had a series of executive orders. So the first one he did was Executive Order 142, or what we in the housing world know as the June order. And this was back in May when we thought COVID-19 is going to be over by July 1st, right? So it imposed a moratorium on evictions for late payment and non-payment, and it was only in place for 21 days, but it was strategically placed to cover what would have been June rents. And what it said was you can't evict on the basis of non-payment of June rent, but landlords now had the responsibility of finding a way to cover the deficit that June would create over the course of their lease. So what you see is a lot of people do an amortization over, maybe 6 months left on a lease. Amortization, that June rent, break it up and add a little bit to every month's rent moving forward from that point on. Afterwards, we get Executive Order 171. And Executive Order 171 is coming up in a time where the CDC order, which we'll talk about shortly, was under serious challenge in federal court. There were landlord lobbies who did not like the fact that the federal government was sticking their nose into what is essentially a constitutionally protected right to privately contract with whoever that you want. And if there was a government entity that needed to say anything about these private contracts, that power was reserved for the state. So the federal government said, well, no, we are stepping in because this is a public health concern for the entire government. And there was a lot of fighting back and forth, and people thought at the time the arguments made by the apartment associations were pretty strong. And if they were winning, if they were able to win, that CDC order would have died in roughly October. So what happens is our governor takes the additional step of instituting Executive Order 171. And it helped in a lot of different ways. First, the CDC order provided that everybody in the household had to fill out what's called a declaration form in order to get the protections of the order. Well, Governor Cooper's Executive Order 171 said, no, if one person from the household submits it, that's fine. In addition to that, he also provided the responsibility on part of the landlord, excuse me, to notify the court system that they have received the declaration form. So as you can imagine, when the CDC moratorium went out, everybody was doing whatever they wanted to do, and the jurisdictions were not consistent in whether or not they even honored the CDC order. So this, at least for all 100 counties of North Carolina, expressed that we were going to honor and support the CDC order. And in addition to that, if somebody decided that they were going to violate the CDC order, his executive order makes it a Class 2 misdemeanor. So this went into effect in October 30th. One of the conditions on that also has to do with creation of the NC Hope program and having another means for people to be able to access rental assistance funds in a crisis. Lastly, we have the Executive Order 191, which just extended Executive Order 171 to be consistent with the extension of the CDC moratorium that runs now through March 31st. So those are three things that were very, very helpful in keeping people from being evicted en masse, but they weren't the most helpful. The most helpful thing actually was something that wasn't even designed to do anything about housing cases. And that has to do with the Chief Justice's emergency directives. So over the summer last year, the Chief Justice grew concerned about how fast COVID was spreading throughout court personnel all throughout the state. And what she decided was she did not want the court to become essentially incubators for COVID-19 to risk the staff and personnel of the courthouse. So there was a reduction in the kinds of cases that could be heard live in court and it was limited to those cases that were deemed to be essential. So first appearances for criminal cases, domestic violence protective order cases, but summary ejectments weren't deemed to be essential. So what that meant was landlords could still go to court and file actions, but those actions wouldn't be scheduled for hearings. And because those actions wouldn't get scheduled for hearings, it gave tenants advocates a lot of time to try to work with different area nonprofits and groups to try to resolve the issues. Lastly, I've alluded to it before, but there's the CDC order. The CDC order requires that a declaration be provided from the tenant. And that declaration has to be signed under penalty of perjury and has to show the following. One, that the person is using the best efforts to obtain government assistance for housing. Number two, that they make less than $99,000 a year if they're an individual, or less than $198,000 a year if they're married. So as you can see, it's supposed to cover a wide latitude of people. Unable to pay rent due to substantial loss of income, loss of compensable hours of work, wages, layoffs, or extraordinary out-of-pocket medical expenses. And that they have to stipulate they're using their best efforts to make timely partial payments that are as close to full payment as their circumstances will allow. The issue with that is a lot of landlords in North Carolina will not accept partial payments because they don't want to risk waiving their ability to evict if they don't collect on the full amount. So oftentimes this will be signed and the person will still go and try to make their partial payments, but those payments will get rejected and they still qualify under this. If evicted, I would likely become homeless, need to move into a homeless shelter, or need to move into a new residence shared by other people who live in close quarters. That's essentially everybody who's being evicted. And I understand that I must pay rent and comply with other obligations that I might have under my tenancy, lease agreement, or similar contract. The difference here is this order does nothing to offset late fees, penalties, interest, any of that stuff. So all it does is it allows for the person to remain in the home until the expiration of the order, but it's a gift and a curse. The gift is being able to stay and have a roof over your head in the interim. The curse is these deficits are going to continue to accrue. So if you're there, and at this point, people have been in place for 8 months. If you've been in place for 8 months, but you still don't have a job, you haven't gotten employment, and you're still running up a bill, plus late fees, plus penalties. And so the fear now is when the CDC moratorium ends, there's going to be an uptick in evictions, and there's going to be an uptick in people who, for all these cases that have been accumulating since August, those cases have to get rescheduled and ultimately get heard. And there's going to be a lot of sad people who aren't going to be able to pay off the deficits unless there's some program in the area that can provide rental assistance. So initially that CDC order ran through December. As you all know, it was extended through March. And it placed the burden on the tenant to do and deliver all of the documents that were necessary. But again, in North Carolina, our distinction is that that executive order has shifted that burden to the landlord. So I put a little slide in here to make a shameless plug about our eviction diversion program. If you are in Durham County, this is the program that you should send tenants who are trying to deal with issues with rent to. It's a partnership between Department of Social Services, Legal Aid, and the Civil Justice Clinic. And the whole point of the program is that we wanted to set it up so that people who needed rental assistance and nothing further could access that through emergency rental funds housed at DSS. But for people who had other issues beyond that, to be able to get a legal review and analysis of their situation. So when the cases leave DSS, they first go to Legal Aid's centralized intake unit to see if they qualify for potential Lance representation. Legal Aid has eligibility criteria that's set by the Legal Services Corporation. And so as a result, Legal Aid can't represent members of our community who are undocumented or people who make over the LSC income threshold guideline. So those cases end up coming over to me at the Civil Justice Clinic, and my clinic is able to use advanced level law students who are seeking court experience, and they get the opportunity to interview the clients. They get the opportunity to attempt to negotiate resolutions with the landlord where they can, or in situations where we cannot negotiate resolutions, to represent the tenants in court. If you are not in Durham County, I would strongly encourage you to call 211 and find out what emergency rental assistance programs are available in your area. There are a number of eviction diversion programs at this point. I think there are about 6 that I know of in the state, but they're very localized. So if you are, I think it's Mecklenburg, Guilford, Orange, Durham, I believe Wake is trying to set one up. So if you're in those areas, you probably have something that's more streamlined. But if you are not in those areas, please be sure to call 211 and find out what's in your area. So I want to talk to you a little bit very quickly as I come to the end of this presentation to talk a little bit about kind of what you do in these negotiation strategies. So the first thing that you always want to do is you want to identify if you have any COVID related defenses. And the only way that you're going to be able to do that is first, ensure that the client has done a CDC declaration form and provided it to the landlord. Second, you want to make sure that in the court file, the landlord has upheld their responsibility to file a CARES Act affidavit, because the landlord has to say to the court system, either I am not federally backed and this person does not have a federal subsidy, or the alternative. If it's the alternative, then we're looking to see what the basis of the eviction is. And if any portion of the basis of that eviction came up between March and July, then that would be barred by the CARES Act. So you're looking basically at the ledger to see what's been paid in, what the landlord is claiming hasn't been paid in, and what the landlord has the ability to try to go back and collect. And again, during CARES Act, there should be no additional late fees. It's only the rent. June rent is the thing that fell under the executive order. So if there is an attempt to evict on the basis of June rent and June alone, they cannot do that. Now, at this point in the game, more than likely it's not just June, right? So, but you still want to always check the ledger, because people evict for all kinds of wild things and no two eviction cases are alike. If they're seeking rent or late fees for period that are exempted by a CARES Act or a governor's moratorium, it could also serve as a basis for a Chapter 75 claim as an unfair and deceptive trade practice. Doesn't necessarily mean that it is, but you would want to evaluate it just to see. And then, of course, because the governor's moratorium issues out also a Class 2 misdemeanor for violations of his executive order, there's a possibility. I haven't heard of anybody being prosecuted for it yet, but there is a possibility of it. You also want to identify if there are any counterclaims or defenses. So again, habitability is the big thing. If somebody complains to you and they say, I've had roaches, rats, bed bugs, anything like that, you want to make sure that you kind of chart out, when did you first put the landlord on notice? When you say infestation, how many are we talking? Do you have pictures? Is there video? Have you called the housing inspector? If you have gotten an inspection, please provide me with a copy of said inspection. So you want to find out if there legitimately are habitability concerns that could potentially offset what the landlord is going to claim is owed. Likewise, if there's been any kind of unfair debt collection or any kind of unfair and deceptive trade practice, again, habitability concerns can bleed into that unfair and deceptive trade practice as well. But I also like to look out for things like fees that landlords threaten to charge if somebody complains about a condition, right? That's an unfair and deceptive trade practice, because the effect of that fee is to stop people from being able to make lawful complaints about the conditions of their unit. Lastly, you also want to always check the notice, as I've emphasized earlier in the presentation. Notice is important. If the notice is bad, then the whole case is bad. So always get a copy of that notice. For most tenants who are facing eviction for non-payment, the CDC moratorium should at least delay the eviction. And again, this is changing as we speak. So this March 31st date may not be the date anymore. I just haven't had a chance to look at what the new changes are. Landlords in some cities have been willing to accept discounted percentages of the rent, as opposed to waiting on other sources to provide emergency rental assistance. But anytime that you have an issue like that, please direct tenants to call 211, find out what assistance is available in the area. Also, the beauty of the CDC declaration, at least on the onset, was that it postponed cases until April of this year. Now, we're getting close to April now. In Durham County, we've actually had a district court judge who entered an order saying that they're not going to hear cases based on failure to pay rent until May. But that's just for Durham County. If your county has done something like that, great. If not, you can always try to talk, because one of the issues we're seeing in the community is that the agencies that provide emergency rental assistance got slammed during the period of COVID, and the demand was astronomical. So they haven't been able to keep up with all the numbers of people who need assistance. And as a result, they're running months behind on the gap. And our judges at least didn't want to be evicting people who are already applied for the system and already eligible for the rental assistance, but just hadn't had enough time for the processing. So it's something to look into. And then if you do go to district court, our statutes mandate that you can get one continuance if either party is seeking discovery. And I would always recommend that you do that, because discovery is important, even in cases to verify that there's a lease and to verify that there's that the ledger is accurate. You want to get a copy of that in your discovery. But it could also be the doorway to open up a whole bunch of other issues as it relates to complaints in the past about the habitability concerns. And then lastly, I've never done this, but after the district court judgment is entered, there is a 30-day appeal window to appeal the case to the North Carolina Court of Appeals. And again, we've talked about this before, but tenants are generally unrepresented. So if you are representing a tenant, landlords often aren't prepared to face you in these hearings, and they oftentimes aren't prepared to carry their burden without using hearsay evidence. And so to the extent that you can either buy someone time to be able to orchestrate a move, or to be able to get the case dismissed outright, you're going to have a lot more success in doing that than the tenant will be in and of themselves. So that's it for me. If you have any other questions, I am happy to entertain those at this time. I hope I did not bore you to death, but I wanted to make sure that I gave you all the information. Everything that I know up here, you now have.
Jesse, first of all, thank you. That was awesome and really, really interesting. We do have one question, and I just want to tell all of our listeners or attendees, again, the code word that you'll need is SAM, S-A-M, for your CLE form that you'll get either later today or tomorrow from us. And then we've got one more question for Jesse, and then that will be it for our CLE for today. So thank you everyone for attending. So somebody was asking if mold could serve as a basis for a habitability claim.
Great question. So the lawyer answer is it depends, right?
Always.
The mold is a naturally growing substance. And because it's a naturally growing substance, the landlord isn't necessarily going to be liable for mold growth. However, we know that there are various types of mold. Some mold is toxigenic. And if the mold is tested and determined to be toxigenic, then the landlord would be under a responsibility to alleviate the mold. More common, I've only had one case with toxigenic mold. More common, what you deal with is mold that people have a unique or acute sensitivity to. So if there are potential personal injury damages, if somebody's going to a doctor and the doctor says the reason you now have asthma, or the reason that you're coughing or can't sleep or whatever is because you have acute sensitivity to a certain kind of mold, and you can test the mold and find out that that's the kind of spore that is growing in the unit, then yes, absolutely. Now it becomes a habitability concern for which the landlord will be responsible, not just for remediating the mold, but could also be held potentially liable for the personal injuries as well.